Anyone have idea? Hello, everyone hear me? Everyone still in the class? Okay, so anyone can answer the questions. Why contributory negligence will not apply in the case of strict liability?
Um, Excuse me, Miss. I would like to answer this question.
Yes.
Yeah. Well, I think the contributory negligence cannot be applied in strict liability because in the strict liability, the injured party usually like has the injuries that which can be recoverable. That means yeah, recoverable and how can I say? Uh, that means that I think that the injuries can be recoverable. So, but however, in the contributory uh, and in the contributory negligence, it has mentioned that the plaintiff has the injury which cannot recover, and this one was made by themselves. So I think that's why we couldn't apply this negligence in strict liability.
Mm. Anyone else? Contributory negligence means that when the plaintiffs also contribute to fault, right? and then the plaintiff may not be able to claim damages from the defendant under contributory negligence. Anyone have different idea? You know that for strict liability, you can't see. You do not have to prove that there is a fault. Remember the key difference between strict liabilities and negligence is that in strict liability, when you make claim under strict liability at a plaintiff, you do not have to prove fault. So because you do not have to prove fault, fault is not one of the elements. So therefore, the defendant cannot argue that because you also contribute to fault, we will not be liable. Understand what I mean? Everyone? So that is the reason why it rarely applies, okay, in strict liability. Of course, it still applies in case of negligence, right? Okay. So I just want to put here about the comparative negligence together with contributory negligence as well, because they are relevant to each other. Okay, comparative negligence allow the allow the plaintiff to claim damages even though the even though the plaintiff contribute to the negligence or to fault. Okay, and the first two sentence is actually a general rules about comparative negligence, and you already hear free to make presentations on the comparative negligence, right? And you know that it depends on whether the state apply poor comparative negligence of 50% rules in which the damages can be proportionally share between the plaintiff and the defendant. That is the general rule. And comparative negligence may apply in strict liability because in that case, you know that strict liability, the defendant is liable regardless of whether the defendants were at fault or not. But if the plaintiffs also contribute to the fault and therefore the amount of damages that the defendant have to pay could be reduced. That is also applies in strict liability. Even though it can't be released, the defendant cannot be released from liability, but the amount of damages that apply could be reduced. Understand? All right. So I think that now I would like to add group 4 to make a presentation. Okay. So I will allow you to share the screen. Group 4, sorry. Yeah, you can share the screen right now. Yeah. Please, group 4, sorry.
Can you hear me?
Yep. Yeah. Everyone, group 4, please show your face on camera, please. Yeah, I see Hoàng Bảo, right? Bảo Hoàng or Hoàng Bảo? Sorry, Bảo Hoàng, right?
Bảo Thi ạ.
Bảo Thi, okay, Bảo Thi. I'm sorry because the names appear here. Ngọc Thảo, right? Correct?
Yes, Miss.
And one
Yes.
more.
Tiên ạ. I'm here.
Who? Tin, right?
Yes,
Tin.
yes.
Okay, good. Yeah.
So can I start?
Yep, sure.
Okay, so hello everyone. We are reporters, which include Ngọc Thảo, Triều Tiên, and Bảo Thi. So today we're gonna present two particular case studies of the Ford Motor Company, which are considered to be typical cases in tort law. Here you guys can see on the screen, we have two cases. One between Ford Motor Company and David Dobrovany, and the second one is also this company with Star Chapkerson. So right now, I'm gonna talk about the first case. Let's spend 30 seconds reading this case together, huh? The case is David Dobrovany bought a new truck, and a year later, the truck automatically caught fire in his driveway, and the truck was destroyed after that, but there were no injuries and no damages in properties. Then he filed a suit against this company. In this case, we have two questions that need to be solved. The first one is Mr. Lee claim likely to success under US law? Is there now the basis for liability on which he might recover? And the second question is, would our answer be different if we apply Vietnamese law? So let's move to the first question. In order to answer this one, we have searched for some materials and information that our final conclusion is Mr. Lee does not have beneficial changes, that the court makes decision in his favor under the US law. To explain why, I could say that in respect of strict product liability, the aims of this liability is to guarantee that the defective products cause the cause of injuries which occur by the manufacturers without relating to the injured parties. And in addition, he also didn't present precisely about any details mentioning the requirements for the recovery. Particularly, the proof should be attested sufficiently, such as the existence of the violent and sudden event happening. Thus, the violent and sudden event will be applied as evidence to prove the reason for damages, and the products could be judged as defective. In other words, the truck was owned by Mr. D, being caught fire in the driveway and had no physical harm to the person or by the use of the property. Therefore, he could not file a lawsuit against Ford under the strict product liability. Besides considering all the basic liability that Mr. D might recover, although he could not claim the compensation under the strict product liability, he still could argue the product design which is defective and causes the fault. Moreover, he might recover by analyzing the product value and quality, which are also the motivation of the warranties. On the grounds of the breach of warranties requirements, he could show the request for the rent as the loss of his truck to recover on the contract principles. Overall, for the first question, we could conclude that Mr. D is unlikely to request compensation from Ford Motor Company under the US law. However, he could sue the request for the rent as the loss of his job to recover under contract principle. So thank you very much for listening. And the next part will be in charge Ngọc Thảo. She will continue and explain for you guys to understand more about this case under Vietnamese law.
Okay, thank you, Conti, for the first section of the case number one. Okay, now we move on the next question of our very first case. So you can, okay, Claudia, you forgot to unmute. Sorry, you forgot to mute. So the question B of the first case, that is, would our answer be different if Vietnamese law applies? So, according to our analyze, excuse me, Bảo Thi, could you please click to present, please? Okay, thank you. So according to our analyze, our answer that is the answer will be the same with U.S. law that we have mentioned in the first question. That is, Mr. Dev is unlikely to be success if he filed a lawsuit against the Ford company. And to explain why, we would like to show you about the laws that we have analyzed in Vietnamese law. So could you please move on to the next slide, please? Yes. Wait, excuse me. Back the last slide, please. Okay. And before we move on, the Vietnamese law, I would like to show you again about two types of strict liability. The first of all, that is abnormally dangerous activities, and the second one, that is the product liability. So I think that when you read the case that we have shown you at the beginning, we can see that in this case, the factor that is after 1 year since Mr. David bought a car from Ford Company, and one day when he drove it, is suddenly being caught fire without any reasonable reason. So that's the reason why we can see here there are no any reasonable factors can show us like the highs or the evidence to that leading to the abnormally dangerous activities. So to understand more, we also mention again that some activities that we could understand that they are abnormally dangerous. For example, like crop dusting, storage explosive like gasoline, right? Or maybe wild animal as pests. So if we can see some action or some factor like that, we can suppose that we can make the conclusion that they are abnormally dangerous activities. But in this case, we can see that there are nothing can reflect that. And the second type of strict liability we could also show on our screen, that is the product liability. So to be clarify this one, it can be understands like the liability of manufacturer or the seller, or maybe other for the injuries caused by the defective products. So the defective products here, we can understand that is the product is manufactured in the properly way, in the proper method. So that's the reason why we can as we can move on the next slide to read three clauses that we have quoted from Vietnamese law. So first of all, we can see here that is the laws on products and good quality 2007, and especially that we would like to talk about clause 1, article 61 about compensation liabilities. The second point we would like to mention here, that is the clause 1, article 23 of laws on protection of consumer rights to 2010. And the last one in the Civil Code 2015. In the Article 608, that is about compensation for damage caused by infringement of consumer interests. So I think that it would take you maybe 1 minute, yes, to take a quick look of three clauses that we have shown you here. So as we can see that in Vietnamese law and in these clauses, they have mentioned about how the defendant or how the liability can be applied relating to the product. And we can see the same, I think that the similar thing in these clauses, that the defendant or maybe the party can be made the conclusion for compensation when the producer, importer, and maybe manufacturer they produce like the defective products. The defective product here, that means the product which is not comply with the satisfy or maybe the requirement that they need. Okay, and they have something which is infringed. So that's the reason why we can see here, in the case about between the Ford company and Mr. David. Mr. David bought the car from the Ford company, and after 1 year, when he bought that, it was being caught when he drove it on the driveway. So that we can see here that is something that we cannot determine the which is the facts that leading to the reason that whether the car is a defective product or not, because we think, okay, we move on next slide because I would like to show you about our analyze. Yep, so could you please move on to the next slide, please? Okay, so as I have mentioned here, that is in this case, is something that which is not a little bit vague, because maybe that during in the duration after 1 year when Mr. David bought a car from the Ford company, is maybe that there are something has happened when he used the car, or we can see here that it may be the car's owner's activity. For example, if he add other electrical devices into the car, or maybe that he smoked in the car, or maybe that he did not maintain the car properly. Sometime maybe that he could, if he put the car in the garages that did not guarantee about like the repair quality. This example can exemplify that it can cost to the defect of the product, but this one is not originate from the Ford company, because I think that when Mr. David decided to buy the car from the Ford company, of course that he need to examine carefully that about whether it comply enough requirement about the product or not. So that the reason why is has many difficulty to determine that whether this car is defective or not, or maybe where the faults come from. So that's also the reason why we enter into the conclusion that under Vietnamese law, it will be the same with U.S. law, that Mr. Dobrovolny is unlikely to request the Ford Motor Company for compensation liability. And the reason here, there is no evidence proving that the defect come from inside the car or from the production process of the Ford company. So this is also our conclusion that I have mentioned. And now that is also the end for the first case. We still have one more case, and then Ju Tin will be on the stage for that.
Okay, so thank you, Thảo. Hello, guys. I'm Tin, and I'm in charge of the first question of the second case. So before jumping into the answer, I would like to give you guys 30 seconds to read the summarize and the questions on the screen that I'm showing. So time's up, and I have some small questions for you guys. So for the first questions, what is the legal issue in this case? So who would like to volunteer to answer the question? Okay, so I would like to invite Vinh to answer the question. What is the legal issue in this case? Vinh, are you here?
Yes, I'm here. For me, is the legal issue here is could Ford be liable under U.S. law for arguing that the seatbelt was defectively designed? I think so.
Oh, okay. So, um, are you right? Thank you for your answer. And for the second question, anyone volunteer to make a guess of whether the court would make the decision in favor of the company or in favor of Shane stock? Uh, anyone volunteer? Thảo Vi, can you answer the question? Make a guess of whether the court would make decision in favor of the family or the company.
Yeah, I think it's I think it's related to the company.
Also, you think the court will make the decision in favor of the company?
Yeah,
Okay, so why do you think the court will make the decision in favor of the company?
I think it's related to the product liability, but I'm not sure about that. Yeah.
Oh, yes. Thank you for your answer. And yes, your answer is true. And that is the keyword that matching our analyzers. It is the um, liability. And so to understand further in why the U.S. court made its decision in favor of the company, I will explain to you now. So, uh, can, Tay, can you move to the next slide, please? Okay, so um, when uh, when people suffer an injury from using a product, they often sue the manufacturer. However, what happens if the consumer themselves are the one who misuse a product? Is the manufacturer still liable? So to solve this matter, there is a defense to product liability uh, called misuse of the product, which is the main point of my answer to the first question. So after some research is based on the misuse of the product, we have to come to the conclusion that Ford couldn't be able to couldn't be accountable to the liable under the U.S. law. So first of all, I want to give you a brief explanation of misuse of product. So misuse of product is a valid defense against liability according to the Uniform Comparative Fault Act. Misuse of a product means a misuse giving rise to a danger that could have been reasonably anticipated or guarded against. However, the act does not apply to the misuse giving rise to the danger that could not reasonably have been anticipated or guarded against by the manufacturer, so that the product was therefore not defective or unreasonably dangerous. This means that if the manufacturer can prove that the consumer was ignoring the warning labels or deliberately misuse the product, the manufacturer isn't wouldn't have to have the responsible for the damages or the dangers. For example, uh, for you to understand further, please can you move to the next slide? If a person decides to stand on a chair, but then that person falls and got injuries uh, from that falls because the chair collapsed, the manufacturer could argue that it is foreseeable that someone might fall from standing on a chair. However, it is not a reasonable misuse of the product, as the fact that the chair is designed for sitting, not to step on, not as a step ladder, and the chair was not broken as the first place. So similarly, in this case, I think, can you move to the next slide? First of all, Ford stated that the car and the seatbelt system was safe and reasonably designed. And second, Shane Stark was she was using a seatbelt designed by Ford. However, instead of wearing it properly, she was wearing the shoulder belt behind her back, which is an alteration or modification to a product that was used without the manufacturer or the seller's permission. There is also no reasonable reason for her to use the belt this way. So as all the factors that I had mentioned, we had come to the conclusion that Ford is protected from liability due to the modification or alteration under the U.S. law. And that is the end of my presentation. For the next question of this case, Thảo will be in charge to answer for you guys.
Okay, so hello, teacher and everyone. I'm back again for the question B, also about Vietnamese law in the second case. So as Bin has tell you about like the legal issue and our conclusion, that is the family, according to the statement of Ford, that is Ford will be protected from liability due to the modification or alteration. So the question in the next question, that is, would be the answer be different in case the Vietnamese laws applies? So now in our screen, I would like to show you about two clauses that we have analyzed, and we think that they are relevant to the case. So now we move on the next slide. So in the next slide here, we can see that we have quoted two clauses of the law on protection of consumers' rights to 2010. The first one is the Article 23, which illustrate about the liability for compensation for damage caused by defective goods. So I think that you guys still remember about the defective goods. Defective goods here, that means the product has been manufactured improperly. Maybe that about manufacture, maybe about design, or maybe about failure to warn for the consumer, or maybe about packaging. Okay, so that is they are defective goods. And the next clause, that is in the Article 24. Okay, in the same law, which prescribe the exemption from liability for damage caused by defective goods. And when you read both of clauses, I would like to emphasize you something in, sorry, wait for me. We are still the old slide, sorry. We are still the old slide, yeah. Okay. Oops. Excuse me, what's wrong? Okay, Bảo Thi, please, we move on the slide of two clauses.
Which one?
The law. Article 23 and Article 23, yeah, and Article 24. The next slide.
I can move
Okay.
this.
Okay, thank you. Okay, so on my screen now, you can, okay, again, that is, they are the Article 23 and the Article 24. Sorry for this inconvenience. So in both clauses, we can see here that we have mentioned about it had mentioned about the liability for compensation for damage caused by defective goods. So we can see here, if an organization or individual trading good, they shall be liable for damages in the case where defective goods which are supplied by them, and they have to cause damages to life, health, properties of consumer, even if the defects are not known to or not caused by the organization or individual. Or maybe in the Article 24, describe the exemption from liability for damage caused by defective goods. We also can see that they have mentioned the organization or individual trading good that we have mentioned in the previous article shall be exempt from compensation if they can prove the defects of the goods could not be detected with the scientific and technical knowledge at the time that the organization or individual trading good supply the defective good to the consumer. So, in other words, we could understand this one that is the in this case the fourth company would be liable for the damages of the family, especially for Cheyenne, about like her injuries, only when we identify or there are about the evidence about her injury originating from the defect product of fourth company. But in here we can see that at the beginning of this case, Ford stated that the car and the seat belt they manufactures were safe, and they were designed reasonably. So that means there are no defect or the goods are not defective in this case. So that's the reason why if the car was involved in this collision, one needs to first examine that whether the proximate cause of the Cheyenne's injury was anyway to do with the manufacturing defects in the seat belt, or whether the misuse of seat belt was the cause for the injury. So in this case, Cheyenne was not wearing the seatbelt properly because we can read at the beginning of the case, right? That is, she was wearing the shoulder belt behind her back. And moreover, one thing that in this case, that is the car is owned by her parent. So that means if a 5 years old girl, that is Cheyenne in this case, when he sits in the car, which is not how can I say, which is not manufactured for especially purpose, like for the kid. So the parent has prepared a booster chair, but she didn't sit on that. She sit on the chair of the car and wear wrongly the seatbelt. So that is the reason why it leads to her injuries in the spinal cord after the collision. So in this case, that the as some factors that I have pointed in the case, I would like to emphasize again that is matched with it is matched with the law in the Vietnamese law, sorry. That is, the defects of the goods could not be detected with the scientific and technical knowledge at the time that organization or individual trading good supplying the defective good to the consumer. So this one is the statement of what I have mentioned. First of all, the car and the seatbelt were safe and they were designed reasonably. And the second thing that is Cheyenne was not wearing the seatbelt properly. And her injury about in the spinal cord it was caused because the seatbelt was not working for her. So that's the reason why we can enter into the conclusion that a Ford is an exemption from liability for damage caused by defective goods, and it is not accountable. It is also accountable under Vietnamese law. So Again, this is our conclusion. That is, Ford also wouldn't be applicable in this case under Vietnamese law, is similar as under US law. So that is also the end for our presentation. And thank you so much for your attention. And now, if you have any question, you can feel free to ask us. Thank you.
Okay, everyone. So group 4 already finished their presentation. Anyone have any questions? Please raise your voice. You can raise the question for case 1 first. So group 4, please solve the problems for K1, please. The full problems that I send you. Next slide. Can you move to next slide when you point out the legal issues? The legal issue, please. Previous slide. Yep. So what is the legal issue? Anyone have any comments about the legal issue?
Excuse me, miss, the legal issue here that it is relating to the strict liability.
But can you put the legal issue at a sentence, the sentence for the legal issues?
I would like to talk about sorry the legal issue here, that is whether Mr. Del Provoni here can be susceptible if he file a lawsuit against a Ford company
Under
and under the strict liability doctrine.
yeah, you
Ah,
need to say
that is yeah.
Can you complete the sentence, please?
Yeah, okay. So the legal issue here, that is whether Mr. Del Provoni is susceptible if he files a lawsuit against the Ford company under the strict liability doctrine.
Yeah, the strict liability doctrine. And your conclusion is not, right?
Yeah, our conclusion, that is he couldn't be made in favor.
What is the key reason for you to come to that conclusion?
Um, As our analyst, we think in this case, when his car was being caught in the driveway, there is no injuries about the personal or maybe about the property. So that's the reason why we think here he couldn't be successful if he filed a lawsuit and under the strict liability doctrine.
But how about the truck? The truck was destroyed. The fact given in the case that the truck was destroyed because of the fire. The truck spontaneously caught fire. And this is a new pickup truck that David bought from Ford Motor Company or from the distributor whatsoever. But that is the new truck he bought from the company or from the distributor, okay? But then the truck was destroyed because it spontaneously caught fire. What about that facts? Did you examine that fact? Is it a damage? The truck was destroyed. So in order to prove strict liability, what elements that you need to prove?
We think that we need to analyze that the liability is not fault.
No, what other elements? What other elements that you need to prove? Liability without fault is just a definition of strict liability and help you to distinguish between strict liabilities and negligence. It's not an element to recognize strict liability. What are the elements to recognize strict liability or to prove under strict liabilities?
Yeah, I think that is when there are certain activities which can place the public at risk of injury, even if the reasonable care is taken. Uh, and the public should have some means of compensation if such injury happens.
So the first elements is
Yeah, the first element, that is there are certain activities that can place the public at risk of injuries even if the reasonable care is taken.
No, that is not the element. Anyone have any idea? Anyone in the room? You can discuss within your room in order to answer the questions. Otherwise, student in the class may answer that question. What are the elements? That is very important for you to take legal action under strict liability. You need to point out what is the element. What are the elements that you need to prove?
Okay, I will answer the question. So as we discussed, I think there are two elements. The first element is the plaintiff must prove that the products were inherently defective, and the second element is the defect of in the products caused the injury or the damages.
Yeah, that's correct. So you need to examine two elements. The first element is that there was a defect in the products, and second one, that defect caused loss, injuries, or damages, or damage to the plaintiffs.
Yes.
So in this case, did you examine those two factors?
Okay, so we have seen that the plaintiff Dobrovony did not present precisely about any details mentioning the like the group of the product that caused the fire. So
That's why you need to examine, because the car by itself get burned, not because the other outside element, but by itself. So you need to examine that.
Miss.
Yeah.
I think said before that the first element that the plaintiff must prove the product was inherently defective, and in our group, we have said that Mr. D didn't present precisely the evidence to prove that the car fire by I mean that he didn't show any evidence that the fire caused by the error by the defective car, and how can I say here he didn't present any details mentioned that em nói tiếng Việt luôn được không cô?
Try to speak English, please.
Yeah, I think that his idea that she would like to talk that the first element that we need to examine that whether the product was inherently defective or not. But here, Mr. David, he did not show about the evidence to prove that the car was inherently defective at the beginning. So that's the reason why we could not conclude that the car is a defective product or a defective goods that leads to the damages of the truck or the loss. Yeah.
But at least you have to argue. At least you have to examine the facts. Okay, you have to examine the fact. You should examine from the facts of the case. Okay?
Yes, Miss.
Yeah. So otherwise, it's not persuasive. Okay? It's not persuasive because you say, yeah, in your explanation, I can't see any relevant to the element given by strict liability requires under strict liability. Understand what I mean?
Yes, Miss, we understand that we should examine that why the car that is supposed like a product which was inherently defective. Um, yeah, and it seems like we got some misunderstanding about the strict liability, and it leads to some ambiguous information that we gave to everyone.
Okay. All right. So if now you already understand the differences between the two, right? And then between the two set of elements when you take a legal action under negligence and strict liability. Once again, I just want to emphasize that in order for you to take a legal action under strict liability, you have to prove two elements. The first element is that there is a defect in the products. And second one, that defect cause injury, loss, or damage to the plaintiff. So if the two elements are satisfied, and then you will be able to claim, okay, under strict liability. Now, I have another question. Assuming that he is able to prove, okay, the plaintiff in this case, which is his name is David. David is able to prove that the car have a defect inside that caused the fire. Okay. can he claim damage to his car because the car was destroyed?
Yes, Miss, I think that in this case, assuming that if Mr. David could prove that the defect originated from the Ford company and it caused the loss or maybe the damages, so I think that he can sue for the defective product. And the defective product includes four parts that is manufactured, failure to run, by the design and the packaging. And in here, I think that there are two things that he could sue for compensation. That is, he could claim that the Ford company did not or maybe they did not perform correctly in warned. Okay, that means like the Ford company is failing to warn about like the consumer about some risk of the product that they buy from the company.
May I interrupt? I already tell you that assuming that, okay? Assuming that, okay? All right? There is a defect in the car already, okay? Manufacturing defect inside of the car. And that defect caused the car to be fired, right? So my question is whether David can claim damage that he have to suffer, that mean the truck was destroyed.
Miss, could you please repeat the question again, please? My connection didn't work.
Sorry?
Could you repeat the question again, please? Thank you.
What is your conclusion?
Our conclusion that in case he can prove that the car is defective inside, he could claim his claim can successful to against the Ford company.
Can you say it again? What your conclusion?
Can you hear me clearly?
Yep.
Our conclusion is that in this case, in case that David could prove the evidence that the car is defective, he could claim successfully against the Ford company.
He can successful sue
Yeah.
David sue Ford company in every case.
No, not in very every case, because if that defect or that errors that he could prove in this car and it leads to the loss of the property or the damages, so he could be favorable to sue the lawsuit against the Ford company.
No, yeah,
Because
two elements satisfy. Two elements satisfy. The first one is that there is the defect. He can prove that there is a defect in the car that caused a fire. And second, the truck was destroyed. So two elements are satisfied. So he can claim damages in every place. He can take a legal action in every place in the US in order to claim damages under strict liability.
in the US, I know that in the US now, most the states of the US recognize this doctrine, but not all US.
Can you explain a little bit more about that? Why you come to that
Um,
conclusion?
because because I recall about the historical background that you taught in the lessons, that just most the state now
You
rec-
remember about what? Sorry. Can you repeat?
yeah,
You remember about what?
yeah, I recall about the historical background that you taught
Historical
in
background? Is it,
uh
what do you mean
yes.
about historical? Can you explain a little bit more about the
um
historical background?
yeah, just mean that in we read in the slides of the lesson that most states in the US they recognize the strict liability doctrine. So most state, it doesn't mean all the states. So yeah, that's why.
So you need to like this. You need to conclude that it depends on the stakes that David want to take the legal action. If the law of the state that have a jurisdiction to handle David case actually allow for property damage to be claimed under strict liability, and then David can claim the damage happened to his car. Okay? But if the state have the jurisdiction to handle David case, do not recognize, okay, claiming damage to property as one of the remedies available under strict liability, and then David cannot claim. Understand?
Yes,
Yes, Miss.
we
Okay.
got that.
Everyone understand? Okay. All right. About the second case. Yeah. For the second case, the conclusion is whether the family can successfully sue the companies.
No, I think
No?
the family won't successfully sue the company.
Whether she successfully sue the company, no defense available to the company. No defense available. Look at the fact carefully, everyone. Do you want to change your answer? Or you just conclude that, okay, Fox will be responsible for the damage?
So we think we will change our answer a little bit that for fail to warn um, the consumer about the seat belt. So Shane could use that to
What type of defense? Sorry, can you repeat the name of the defense?
failure to warn.
Failure to warn?
Hey, can you give us a minute to discuss again?
Yeah.
Okay, thank you.
Yeah.
Miss,
Yes.
so after discuss, we think we can paste on the super winning event uh, defense to because the kid Shan Stark she um, didn't sit on the booster seat is the first factor, and the second is she used the seat belt in the wrong way. So that is an alteration and modification of the product or the seat belt. So which is which absolves seller or the manufacturer from strict liability.
Okay. So you said that it's a defense of superseding event.
Yes.
Anyone in the class have different idea? Anyone in the class have different idea about the defense available for the second case? Anyone in the class have different idea?
Yes, Miss, I have different ideas.
Yeah, Nga, please.
So instead of arguing the supervening event, we could talk about comparative negligence in this case. Because when it comes to supervening event, the modification or the alteration must cause injury. But in fact, from my personal opinion, in this case, is it the accident that caused the injury instead of the seatbelt itself? The little girl was not injured because of the seatbelt, but was injured because of the injury, and the seatbelt failed to protect her or to have a proper protection. So in this case, I think that we can talk a little bit about comparative negligence, that they was the girl or the parents or anyone in the car failed to have a decent duty of care to the girl, to help the girl put the seatbelt properly, and their negligence partially responsible for the girl, or her negligence partially responsible for her own injuries.
Okay, that is in a general thought of negligence rather than strict liability. With yeah, I agree with you that maybe it is partial fault. But if you bring the legal action under strict liability, fraud could not be a main reason or the reason for you to claim.
Okay.
So yeah, so that's why I just want you to have something differently with respect to, I mean, strict liability. Defense which is more relevant.
Yeah, excuse me, Miss. I have one question. May I? Yeah.
Yep, yep.
So yeah, okay. So in our presentation, when Tin answered the first question, she has told about like the misuse of the product. So may I ask that is it relevant if we illustrate that the defendant can apply this maybe that this kind of defenses to in this case.
Yeah, can you a little bit explain a little bit more about how you think that misuse could be a defense in this case?
Yeah, I think that in this turn, Tin will repeat again, or yeah, Tin will explain more about the misuse of the product. Tinoy, could you please?
Okay, can you hear me?
Yep.
Okay. So the reason why I think we think the misuse of the product can use as a defense here in this case is um, so uh, uh, so the injury that like the act of the of train that use the seat belt wrongly, she uses wrong. We can see foreseeable that uh, the seat belt wouldn't couldn't protect her from injury if there's any accident happens. um, and um, and and in fact the company or the manufacturer could not uh, uh, for, could not see that happen would happen because this is she abnormally like misuse the product and the consequence is the signal could not protect her is an foreseeable misuse for her for the misuse, but the company for is unforeseeable that that consequences, and so I think uh, we can use the misuse of a product to defend.
What is the key reason that the misuse of the product could actually cause the injury rather than the defect in the products?
Okay,
Is there any defect in the products for the second case?
No, there is no defective in the products in the second case.
Right.
Yes.
Even for the first element, okay, may not be a defect in the products. The main reason that caused injury to the little girl is that because she used the product, used the seat belts in the wrong way.
Yes.
So for that reason, it can't protect her. Okay, when there is a collision, because the collision or the car crash could not cause injury to her if she used the seat belt in a proper way.
Yes.
Okay, so here you can argue two ways. The first way is that you need to argue is that you argue that there is no defect in the products because the injury happened to the little girls not because of any wrong with the seat belt, but it is about the ways that he used the seat belt, she used the seat belt. You can say so at the very beginning, and you can immediately come to the conclusion that, okay, the companies that produce the car will not be responsible. Distributors of the cars also not responsible. But then you should move on to say that even though it could be a defect in the seat belts, but the main reason that caused injury to her is due to the wrongful or the inappropriate use of seatbelt. Okay, and you quote the facts of the case in order to come to the conclusion that products misuse can be used as a defense. So therefore, the company or anyone in a distribution chain of the car could not be liable under strict liability. Okay, because there is a defense available. And yeah, I agree that products misuse could be an appropriate defense in this case.
Yeah, thank you. Yes.
Okay, everyone.
Yes.
Are you with me, everyone?
Yes.
Okay, thank you. So we take a break, okay? And after the break, we will be back for the third shift, okay?